Good morning. I'm Judge Tammy Long Hayward. This is July 17th of 2024. We're here for a civil hearing on the 10 o'clock calendar is the case of Henry Land versus Anthony Dawson. Henry Land versus Anthony Dawson. Who's here on behalf of the plaintiff?
Good morning, Judge.
I'm sorry, Ms. Askew. We started out good with good morning, Judge, and then
This is
you're
Attorney
silent.
Latanya Askew on behalf of the plaintiff.
All right, we hear you
Can you
now.
hear me,
Thank
Judge?
you. Yes, ma'am.
Good morning, Judge. I'm Latanya Askew on behalf of Henry Land.
All right. And on behalf of the defendant?
Hello, Your Honor. If you can hear me good, the video showed up. I wanted to make sure. This is Sean Rooney. I am here on behalf of defendants Anthony and Letitia Dawson, Your Honor.
All righty. All right, so this is the motion for summary judgment filed in this case.
Yes, Your Honor.
All right. Oh, sorry, just making sure I put my notes are in the right order. All right, so are you ready to argue the motion, Mr. Rooney?
Yes, Your Honor, and I do refer counsel to my brief as well if she wishes to follow along. But we have filed this motion to dismiss. We are doing this based on the fact that we state that there is no genuine issue as to any material fact. And this is because the plaintiff, both parties have failed to respond to the request for admissions as provided to them. And we are and therefore intended to judgment on those facts. So Georgia law has long recognized that issues of liability in a motor vehicle accident cases should be resolved by a jury, except in those rare circumstances when a party admits liability or the facts are undisputed. That's Cameron v. Peterson. And summary judgment may be granted only if there is no genuine issue of material fact. That's Georgia Canoeing Association v. Henry. Burden is on the party moving for summary judgment to establish a genuine issue of material fact. And any doubt as to the existence of material fact must be resolved against the movement. That's Holland v. Sandfax. And so therefore, Georgia law states a plaintiff is not entitled to recover damages that the plaintiff could have avoided consequences to themselves. That's OCGA 5111(7). And the court has previously held a plaintiff cannot recover from a defendant if his or her negligence was greater than that of the defendant. That's Union Camp Corporation v. Helmy. In the present case, plaintiff failed to respond to defendant's request for admissions. The defendant specifically asked the plaintiff to admit both that the plaintiff was negligent in causing the subject incident and the defendants were not. Both of these facts have been deemed admitted by the failure of the party to respond to request for admissions, and therefore no genuine issues of fact by which plaintiff could prove that liability in this case exists. As such, defendant respectfully submit that they are entitled to the grant of summary judgment as a matter of law. Thank you, Your Honor.
All right, so for the my question is, was there any interaction or contact between the parties regarding the discovery being propounded?
Yes, Your Honor. We had sent 6.4 letters to the plaintiffs, and we have email records of both those being served electronically upon plaintiff's counsel for both plaintiffs.
All right. All right. Anything else before we move to Ms. Askew's response?
No, Your Honor. Thank you.
Thank you.
All right, Judge.
Yes.
Judge, we've been trying to get your attention. I was completely logged off of Zoom. After we said good morning, my Zoom completely went out. I did not hear opposing counsel's argument. I'm so sorry.
Okay. What he basically repeated was what's in the brief, that it's a motion to dismiss because there were no responses to the request for admissions. I'm reading from my notes that I took as he spoke. And as long and when admissions are propounded, but they're not refuted or there's no response to them, then they're deemed admitted under Georgia law. He cited Cameron versus Peterson, Georgia Canoeing Association versus Henry. He cited the Holland case. He also cited the statute 51-11-7, which requires the plaintiff to mitigate damage as much as mitigate damages as much as possible. Also, the rule that if the plaintiff's behavior was more responsible for the damages than the defendant's behavior, then the plaintiff can't recover. I asked the question of whether there had been any contact regarding the discovery that was propounded, and defense counsel stated that there were 6.4 letters sent. There was email contact, and there to 6.4 letters were sent to the plaintiffs and email contact to the plaintiff's counsel. Did I get that right, Mr. Rooney? Anything I missed?
You summed it up better than I could have, Your Honor.
All right, Ms. Askew.
Judge, can you give me 1 second? I think we did send over admissions. Can you give me just literally 1 minute?
Okay.
Because that's the basis that we got in regard to his brief had to do with the service. They were raising the service issue in regards to their motion to dismiss. And if I'm understanding correctly, they're stating that their motion to dismiss is based on non-responses to the admissions. Am I correct?
Yes.
Okay. Give me 1 second, Judge, because I'm almost for certain we sent that. Your Honor, after speaking with my office, I have my paralegal. She is logged on. We're looking at the documents that opposing counsel sent over. Can everybody hear me okay?
Yes, ma'am.
We never received any admissions. That's the first thing. We received a request for interrogatories in which we responded to, and we never received a 6.4B letter. There was no discovery conference, and as you know, Your Honor, before a motion to compel is filed, there needs to be some type of discovery conference in order to try to resolve whatever discovery disputes, and we never had that. And again, Judge, we never received any requests for admission. Shannon, are you online right now, ma'am?
Shannon Brown, is that who you're talking about?
Yes. I think she was
She's
having issues.
I see video. I see that she's present. I don't see her picture.
Can you turn on your video, Shannon, and unmute yourself, please? I don't know why today we are having computer issues, Judge.
It happens.
Shannon, I'm listening.
I'm gonna have to log off and try to log back in because my audio is not working.
She's going to log off and log back in, Judge Hayward, because her audio is not working. Are you okay with that?
That's fine.
Okay. Hurry up, Shannon.
So let me ask this, Ms. Askew. So it indicates that the defendant's motion was filed on February 8th of 2024, but there was no
Yes, ma'am.
response from plaintiff. Have you always been counsel of record in this case, or are you new to the case?
I have always been counsel of record on the case, Your Honor.
Okay, and you didn't receive the motion to dismiss?
What we received was a notice to be in your court today, and we never received a motion to dismiss. What we ended up doing is going under Odyssey, Judge Hayward, to print off their motion to dismiss, but we were never served. Now, I'm not saying that opposing counsel did anything improper, but if we look at Peach Court, we know Peach Court is having issues as of right now. And the only thing that we received in regards to this case is a notice to be in your court today at 10 via Zoom. We never actually received their motion to dismiss.
Your Honor, I can provide some more information. I do have an email in my email to Ms. Askew, to her email from my secretary that does include the request for admissions that was sent on April 30th via statutory electronic service.
And we never received your request for admissions. We responded to your interrogatories. So I don't understand why we would respond to your interrogatories and not respond to your admissions.
So, I mean, I can share the email. I never got a kickback on it in terms of not delivered. It was sent on the 30th at 5:25 p.m. by my secretary to you, and I'm CC'd on it. And, you know, it's got the RFAs. It's in a Word format as well as a PDF. Your Honor, can I share my screen, or you
may?
Okay, so let me do that. So just do that. And Attorney Askew, I certainly understand that there have been difficulties with Peach Court. I ran into that in another case, and Your Honor, I will say this: in that case, it was where the plaintiff's counsel did not receive a copy of our motion to dismiss, and we reopened the default. So consent. So certainly we are of the position that plaintiffs should have an opportunity to respond if they did in fact not receive a document.
We actually filed, Judge Hayward, we actually filed our response. We've actually filed our response, and Mr. Rooney, you should have a copy of that. We actually did respond to that, and I don't mind Shannon sharing her screen with that. Yeah. And I'm not stating that you did not I'm not stating that you did not send the email, Mr. Rooney. What I'm stating is we never received it. It's hard to believe that we would respond to your interrogatories and not respond to your admissions. We did, again, respond to your motion to dismiss. And, Your Honor, keep in mind, in regards to a discovery dispute, by law, you have to have some type of conference, some type of phone call to resolve whatever disputes. We have not had that. So on behalf of my client, Mr. Henry Land, we would like the opportunity to resolve any type of dispute. As far as admissions, we can have responses sent over today. If you want to resend me that email, Mr. Rooney, we can have responses sent over today. We never received it.
All right, so Ms. Askew, look at the what's on the screen, and let's confirm that that is your email so that we can make sure that because even if the electronic filing fails, you should be able to exchange information by email.
No, ma'am, that's not my email. My email is actually latanya.askew@askew.law.com, and that's the email that's on the Georgia Bar website. LAT as in Tony, ONYA.ASKEW@askew.law.com. My paralegal, Shannon, she's on here. Her email is Shannon, SHANNON, @askew.law.com. my legal assistant's email address, which is on Peach Court in eFile Odyssey. It's info, INFO, at asqlaw.com. The L ASQ, sometimes that email works, sometimes it does not. And that's why the Georgia Bar website has been updated. And that's been updated for the past 3-4 years, Your Honor.
All right, so at this time, the motion to dismiss will be denied. We'll get you an order to that effect. In fact, Ms. Askew, you can prepare the order, make it simple, and we'll go ahead and sign that. And then we'll give you, you said that you've already responded to the request for admissions?
No, ma'am. What I stated is, Shannon, correct me if I'm wrong, we responded to their motion to dismiss, but we
Okay.
did not respond to their admissions. We
How
don't have
long
their
do you
admissions.
need to respond to the request for admissions?
Can you give us 10 days to respond to the request for admissions? And if Mr. Rooney can resend that to us so we can get that over to him, that would be
Okay.
great. And I will,
So
and
I'll
I'll
give you,
schedule a call with him.
Yes,
so it
and
seems this has just been an electronic mix-up. I'll give you 14 days to respond. Mr. Rooney, if you can resend that to the
yes,
correct email address. And then once you all have, ask you if you'll just go ahead and put in the order that the court is going to give you 14 days from today's date to respond to the request for admissions.
yes. And
Yes, ma'am.
so two things I would like to address, if I may, Your Honor.
Mhm.
The first, Ms. Askew, could you please repeat your email, and I'll make sure that I get it, and I will send that right away.
I don't mind. It's Latanya, and it's spelled LAT as in Tony, ONIA dot ASKEW at ASKEW ASKEW LAW.com. And I can always
Okay.
send you a test email, Mr. Rooney, and I'll copy your
Yes,
assistant on there.
I appreciate that. And then the second thing that I wanted to discuss briefly, if I may, Your Honor, had to do with we did. You know what? I bet it was. It probably has to do with the email as well, because we had sent 6.4 letters, but I can nearly certainly say, and as a
They
matter of
went to
fact,
the
I can
same
look.
email, then she
It
would
probably
not have
went.
received them.
It probably went to the same email. So
That's
I will
okay.
definitely. I'll discuss with my secretary, and I'll make sure that the file gets updated. And then, I do appreciate everyone's time. Ms. Askew, I look forward to talking with you further about this.
Yes, sir.
Your Honor, thank you
Yes,
very
sir.
much for
I'm
doing this
sorry.
virtually.
I do have
Oh,
a question,
yes,
guys.
Ms. Brown.
I just want to make sure, especially with the link issues and all of that. So this motion to dismiss was for Henry Land, but not on the companion case, Linda Land. Am I correct?
No, there was motions filed in both.
Okay, so we'll be filing. So this is for both cases. I just wanted to make sure.
That's correct.
Yeah, that's
We only
fine
got
with me.
notice for the Henry Land case.
I don't,
Yeah.
I have Henry Land.
Yeah,
Is
Whoa.
there one that another judge has, or do I have them both?
you have both.
You have,
Yep.
you have
Okay,
Linda and
all
Henry.
right.
Yep.
Yeah, so you can put the case number on both of them, the same case number, same, stuff. Just make sure you reference them both, and that's fine. We'll just do one order.
Okay, sounds
All
good.
right, well, good. I'm glad we had this opportunity, because we would have been running at cross purposes, and nothing would have gotten done. Now y'all are on the same page, and we're gonna move this
Yes.
case along. And if y'all need
Yes.
anything, I'm sure y'all will be able to work it out. But if you need anything, I am here.
Okay, thank you so much.
Thank you, Your
Thank
Honor.
you so
Thank
much,
you,
Judge
everyone.
Hayward. Thank you,
All right.
Mr.
All
Rooney.
right.
Bye-bye.
Take care.
Goodbye.
All right. Ms. Powell, I'm gonna if you need me, just text me, but I'm gonna sign off or I'll just mute until it's time for the 11 a.m.
Yes, ma'am. Thank you.
All right, thank you, ma'am.
Latanya.
Hold on one second. Hold on, let me try to log off of Zoom. Hold on, Shannon. For some reason, so